I'd like to call the meeting to order of the Tennessee Auctioneers Commission for June the 2nd, 2014. If you would, please call the roll.
Bobby Colson,
Here.
Ronnie Collier, Gary Cunningham, Jeff Morris,
Here.
Howard Phillips. You have a quorum, sir.
Thank you. Would you please read the notice of meeting?
This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission website since May 29th, 2014. This meeting has also been noticed on tn.gov's website.
Okay, there we go. It's been noticed, and then we have the agenda in front of us today. It looks like it's relatively short. If any questions about that, we need to adopt our agenda for today.
I move we adopt the agenda.
It's been moved
Second.
and seconded. All in favor say aye. Aye. We're ready for our legal report, our education provider update. Has you got one for them?
Sir, you need to approve the minutes.
Oh, okay, excuse me, skipped it. Sorry about that. We do have to adopt the minutes from last meeting. It's fairly lengthy. I think you guys got a copy of it and had a chance to read it. We need to adopt those minutes and read them and have them into the record.
I move.
Moved by May, it's been moved to adopt the minutes from the May meeting. Is there a second?
Second.
And it's seconded by Howard Phillips. All in favor say aye. There you go. You might want to use it. Now,
The education provider report. I spoke with Ressa and Wendell, and due to a conflict, they were unable to attend, but they did provide us with a update. They said the TAC seminar at Montgomery Bell was well received. The attendance continues to be down, with approximately 55 attendees. Gallery and non-auctioneer firms generally do not attend these seminars, but there was one gallery licensee and one non-auctioneer who attended. I'm going to be working with them over the next week to prepare the fourth quarter's newsletter. They're hoping to publish the rules as part of that newsletter. They're currently working to select the 2015 venues. They're negotiating with the Tri-Cities for the fall. And the participant feedback has been from the program and the business through tough times, working with presenters on topics.
they're going to change up the topics from what they've sort of had the same kind of program going around the state here for the last several.
It looks like they're actually trying to meet the needs of the licensees
Okay.
with what they're doing. So getting through this sort of slow period is one of their focus for the upcoming seminars.
Good deal.
Is there
And maybe
any-
something will come out of our June meeting next week that they can send on the road as well. Julie, are you ready for the legal report?
Yes, I
Under
am.
tab 2, guys.
We only have two matters to,
I had it open.
oh, I'm sorry.
We're ready.
Okay, we only have two matters this month, and they are against, you'll see on the history that this person has no history, but these complaints were both filed against the same person. They are two separate complainants and two completely separate transactions, but I did want to let you know that. The first complaint is 2014006271. Complainant was the winning bidder of a commercial lot auctioned by respondent, an auctioneer. Complainant states that the auction was advertised as an absolute auction. Complainant states that the property was owned by an LLC and one of the members of the LLC was present at the auction and bid against complainant on the commercial lot. Complainant states that respondent allowed the member of the LLC to bid, which should not be allowed in an absolute auction, and the member's bidding caused the price to be higher than it otherwise would have been. Complainant states that complainant received a signed contract after the auction and then received an additional copy a few days or a week later with an additional member of the LLC's signature on it who had not signed the contract right away. Complainant states that respondent did not make sure complainant's spouse signed the contract, although the spouse was also a buyer. Further, complainant states that the contract gave the LLC the right to accept or reject the agreement even though it was an absolute auction. Finally, complainant states that complainant's attorney made a demand for a respondent to return the earnest money deposit paid by complainant, and complainant would like to know the status of the earnest money since the matter has not been settled and it has been almost a year since the auction took place. Copies of contracts relating to the sale as well as other documentation was provided. Respondent states that respondent received legal advice that the sale was compliant. Respondent states that complainant has buyer's remorse and stated shortly after the auction that complainant wanted out of the contract. Respondent states that complainant requested an extension of closing and persuaded the seller to agree to that as well as a lower price. Respondent states that the seller has tried to accommodate complainant in some manner other than returning the deposit, and the deposit remains in respondent's escrow account, which respondent plans to hold until the matter is legally settled either through written agreement of the parties or court resolution. Respondent states that the family trust that owned the property was legally changed to an LLC some years back, and the president is of advanced age and lives in an assisted living facility. Respondent states that respondent learned that one of the members desired to purchase the property from the LLC, and respondent received legal advice that the member could bid because the LLC was the owner-seller and not the member. Respondent states that the member's attorney and accountant attended the auction with the member. Respondent states that complainant was not tricked into submitting a bid and is experienced in real estate. It appears from the real estate sales contract that an LLC was the seller and there were multiple members, and as such it appears to legal counsel that the member who bid was not the seller of the property. It does not appear that there is a violation of TAC's statutes and rules by respondent, and therefore the recommendation is to dismiss.
Say 1 and 2 are tied together.
I'm sorry. It's against the same person, but they're in no way tied together. The
No, not
facts,
tied
it's
together.
two
So they
totally
aren't.
different
Okay.
transactions.
Did you ascertain how many members there were in the LLC?
It looked like from the contract there were 3 signatures, if I'm not mistaken, on there. I don't believe it was specifically stated in the response. There are, it looks like 3 signatures total of on the line on behalf of the seller, the LLC, one of which, the one that was later written in, is the president, who apparently is in an assisted living facility. That's written up the side and it says Prez next to it, so I believe that's who.
Did the other bidder that was a member of the LLC, was he an officer of the corporation?
It's one of the signatures, but that person did not write what their title was on there. I could find that out if that would be something that you all wanted to
Curious
know.
as to,
I did ask for follow-up information about that because it wasn't in as much detail in the original response. It was kind of referenced but not specifically stated. It just refers to the person by name, and it only gives the position of the individual who's the president. This person was not the president. It does not say that. It just says that this person, I'm sorry, that's the wrong one. I don't believe it did give that person's position, but it is not the president.
Did you ascertain as to whether the LLC was in good standing or not?
No, but I can look it up if you'd like for me to.
If they're trying to stand on the fact that there were an LLC selling and that one of the members was bidding against one of the other people, the corporation would have to be in good standing for that to hold water.
Just active with the Secretary of State's office. You know what? I did look it up.
Have to be in a good standing at the time of the auction.
And I printed this on 5/27, which would have been after the auction, because the auction took place on in April, it appears.
This year? No, that was last year.
It was last year,
Yeah.
April of 2013. But as of when I did the search, the LLC that is listed as the seller on here is active with the Secretary of State, and it appears the term duration expires in 2053 or something of that nature.
Okay.
On this, it says complainant states that the respondent, no, wait a minute, let me find it.
Okay.
It says that the contract gave the LLC the right to accept or reject the agreement even though it was an absolute auction. Well, that's something that.
That raises a red flag.
Well, but the thing about it is why would the buyer even be seen? That was something that should be in a listing contract, not a sales contract.
I'll read you the provision that I think the person was referring to. This is on the real estate sales
It
agreement.
would be something a buyer wouldn't even see.
This is within the real estate sales agreement. It says on here, okay, and I can read this because it appears to be a contract. This paragraph was one that was already in there.
That's the contract between the buyer and the seller.
This
right?
is the contract that was signed between the buyer and the seller. I think the paragraph that they're referring to, it says, buyer acknowledges that under the terms and conditions of the auction sale upon which this real estate was offered at auction, that among the conditions announced with this was that this agreement is subject to the approval of the seller. Pending such approval, buyer shall be bound by this agreement with the same force and effect as if no approval were required. If this agreement is not approved by seller, the deposit money paid on account will be returned to buyer without interest, and this agreement shall become null and void. That's what's within the real estate sales contract. It appears to maybe have been, because the names are filled in, it appears to have been a form that this person uses. I did request a copy of the auction agreement between
Do you have a copy of the ad?
the advertisement. I do have a copy of a newspaper advertisement. I'm not positive it was the only one that was ever done, but I do have a
Is
copy.
that ad advertised as an absolute auction?
It says absolute auction at the top.
Okay, that's pretty plain, isn't it? Nowhere in an absolute auction contract do you have the right to bid on the property or refuse to bid.
See, that was the contract between the buyer and the seller.
I have the
It wasn't
auction
the listing
agreement.
contract. That's what's got me confused. Why would you have that in there?
And
I
the
don't know.
What you
provision,
have to go by is what they advertised in the newspaper.
and it does say within the auction agreement, which I did get a copy of that under the other provisions where it's written in, sale is to be absolute to highest and best
Bidder.
bidder. You're right. I don't know how you can read it. A bidder with no contingencies. That's written in there. And so I don't see, that same language in this one. They're two different forms. Maybe that's something that should have been crossed out with
Well,
it being
I personally think you have an auctioneer that needs to do some explaining
about that provision in
about
the.
an absolute auction and then not selling it.
No, he sold
no,
it.
it's
He sold
so-
it to you.
it's
The guy
sold.
just don't want to buy it.
It
He sold
appeared.
it to one of the owners.
No,
they-
it's sold to the complainant.
No.
Oh, you said he was a member of the LLC.
No.
Yeah, but he bought it as an individual.
No.
No.
Y'all are missing the point.
Or he bid on, he
He
would have
was
bought
a
it.
bidder, he did not buy it.
Right,
The
the other guy
complainant
bought
is
it.
the one that bought it and put up the deposit, and now he's trying to get out of the deal.
That's correct. The complainant was the ultimate purchaser. The complainant had no affiliation with the LLC. The complainant contends that that one of the members' bidding was wrongful. The
When
complainant
when did the auction take place?
in April of 2013, and apparently right now, according to when I spoke with the
been over a
the
year.
auctioneer, there's been a lot of delays between the parties. There were some surveys done that were not part of the original agreement that this complainant got the seller to agree to afterwards. And right now, nothing has. It's still pending.
There've been so many
essentially.
there's been so many modifications of that sales agreement that the original sales agreement is out.
And I asked if there were any of them, and he said it had been between the two
Right.
parties. He
No
said,
law-
"I'm just waiting for some direction on
And
what
there hadn't
to
been
do."
any lawsuits filed or anything that we know of?
Not according to him, and I did speak with the auctioneer
this-
because I was asking for a copy of the auction agreement because I wanted to see how that was
We
addressed.
don't have any grounds to do anything based on that information.
And I don't know if you feel that you said you felt like he should be
Well,
instructed. I don't know if you feel a letter of
I
warning.
want to retract my statement because the way you were reading that.
I'm sorry if
No,
it
it wasn't your fault. It was my brain was not absorbing. The first thing I thought that the member of the LLC was the buyer.
No, sir.
He was just a bidder and didn't own the property, right?
LLC is the seller in the sales contract with the complainant. Yes, sir.
I was just confused about why you would have that language in a
I think it's-
sales contract between the buyer and the seller.
I think
anyway.
that's a
So I-
standard paragraph that they just didn't forgot to strike out.
I believe so
I'll
from the
move to
form.
go with legal's recommendation.
All right, it's been moved to dismiss this case. Is there a second?
Second.
Been made and seconded. All in favor, say aye. Aye. Motion carries.
Well, I have one more thing about that. You was talking about the earnest money. Now, he probably is, if he's not going to close, he's probably not entitled to get his earnest money back.
That's what he's complaining about.
And right now, according to the auctioneer, because I did ask the status, well, actually, that was addressed in the response, that it was being held and he was waiting for a written
It's in the
agreement.
next one.
What'd you say?
I'll pay more attention to
I'm
the
sorry, and it's
That's
very,
gonna-
it's very confusing. I know when they're anonymous like this. I try to make them clear, but I'm sorry if it didn't come
He'll
across
probably
as-
need to interplead that earnest money into the court and let the courts decide.
Probably so, and I'm not sure. I was not provided with a copy of a written demand. I don't know if there was a written
Right.
demand or
Right.
not, but apparently there's been a lot going on verbally, so I'm not even positive about that. I just wanted to make sure I had all the copies of the auction contracts.
Got a separate complaint against the same
It's
respondent.
against the same person, different complainant, different transaction,
Okay.
though. This is number 20140077771. Complainant states that respondent, auctioneer, auctioned complainant's house and personal property. Complainant states that respondent falsely advertised the sale as an estate auction, and complainant states that complainant is still alive but just moved to another state. Complainant also states that complainant did not get an itemized list of the items sold. Further, complainant states that respondent charged 20% and then charged another 10%, although complainant states there was nothing in the contract allowing this. Respondent states that a 10% buyer's premium was in the written agreement between complainant and respondent. Respondent states that when respondent mailed the proceeds check, respondent failed to enclose a copy of the sales ticket, which respondent usually provides sellers at settlement, but immediately mailed the sales tickets when respondent was advised they had been omitted. Respondent states that there was no misrepresentation. The agreement between the parties appears to specify that respondent would be compensated with 20% plus a 10% buyer's premium on the personal property. Additionally, the advertisement advertises the absolute auction and states that the sellers have retired and are moving to another state. It does not appear based on the information that there is a violation of tax statutes and rules by respondent. Therefore, the recommendation is to dismiss.
I can make a motion to follow your advice and dismiss it quickly on this one.
Second.
It's been made and seconded. No further discussion. All in favor, say aye.
Aye.
Aye. Motion carries.
That's all I have this month. We have a
Okay.
couple coming up, but that was only two in my office at this time, so.
All right. We have, Kimberly, you got the complaint comparison report, which
Yes,
is in
sir.
tab 3.
Yes, sir.
Not a lot of change in that, I don't assume.
No, sir, we're still doing very well. Again, 97% referred for legal action or closed within 180 days of receipt, and the department's performance measure is set at 75, so we're meeting and exceeding.
Not that it matters, but you might check your spelling on that second block down there.
Oh,
I see it.
Tab 4 is your monthly budget report. Nothing of specific.
Nothing sticks out.
No, sir.
Okay.
Last month, though, you did ask me, the third page of that is the recovery fund information, and
Right.
you had asked for a balance update. And year-to-date, through the end of April, the balance is currently $219,504.
What's our cap, 250? Or is it supposed to,
There's no cap, there's the minimum.
minimum of 150?
Yes, sir.
Right, okay, good. I was wondering, have we had any payments out of that fund that you can recall
Not
while
in
you've been here?
recent years.
Not that Yeah. I
can recall either, Chairman.
Okay. I don't think the general public is aware that that's available to them. I don't know.
At audit's request, both the Real Estate Commission and the Auctioneer Commission published a updated how to sort of explain what people
What the
have to
steps
do
are.
to claim.
Is that on our website?
I believe so.
prepared to go on the website, so
I'll
it's ready,
confirm.
if
I'll
not,
confirm
we'll
that
be
it's
sure
that
to-
it's been.
It would be
published.
nice if it is, and they could research that and see that that recovery fund is available to them.
It's really not anything that's not in the statute, but I tried to break it down in a more
Right.
timeline fashion where it was a little bit easier to understand than somebody just reading through the statute.
All right, what's next? Let's see. 80-hour course application, tab 5.
Yes, sir. And this is actually a represent.
The same
from-
guy.
No, it was a couple of months ago. This is the Ohio Auction School. This is the 80-hour
Oh.
course. And we were previously we had received his information 2 days prior to the meeting, and we knew that he didn't have everything together. So we've gone back. I've had a couple of conversations with Mr. Bradley and
Brandley, yeah.
Brandley,
Mm-hmm.
and he's provided additional information, and I've reviewed it compared to, he prepared his, this was prior to us creating the new form, so his documents have been prepared on the old form. I went through and compared it to the new form to make sure that we had obtained everything that we needed from him. So the first couple of pages are just the application, and then he provides, there's a few letter type documents from him about the physical address, how the exam is prepared. He also attached an outline of the courses, a small narrative about each of the topics that he presents, along with the North Carolina auctioneer licensing application. He kind of details the number of hours that each of the topics are presented. Additionally, I did confirm with Ohio that Mr. Brandley has been licensed since 1985, and he is an active auctioneer.
I don't know Mike personally, but I know of him. He's a member of the NAA, and he and Peter Garris both are very active in NAA, and they've come with very high recognition and background and knowledge of the industry. The Mantles, I don't know, but and then Mr. Fred Wilkes. You may know Fred. Do you know Fred Wilkes? Been around 52 years, but anyway, they know what they're doing.
Is he in Tennessee?
No, he's up in Ohio. This course would be an online only, or a course at their school, or how's it, where were they?
This is an on-site course.
On-site course.
I believe it's a classroom.
That's what it
indicates
in their application.
80 hours, is that the
Pre-licensing.
Pre-license.
Pre-license,
Yes,
that's
sir.
what, yes, what you gotta have.
Yeah.
I think they can handle this very well, and they've been doing it a long time, so I don't see any problem with it, but that's, any discussion on it?
Make a motion that we what? Accept it?
Motion's been made to approve the application. Is there a second?
Second.
Seconded by Bobby Colson. All in favor say aye.
Aye.
Aye. Motion passes for that particular tab 5 there.
As promised at last month's meeting, Julie and I went through and reviewed the continuing education application and have revised it, and you have a new version for your review, as well as the old version. And previously, there was an instructor form that the individuals completed in order to in order for the commission to review the instructors. And we wanted to get some feedback as to what information you're looking for from the sponsor making application for the instructors. What do you need to know about the instructors in order to feel comfortable approving them for the class and to teach? And
Any
this,
thoughts on that?
previously the instructor application had a checklist that at some point the commission had said, these are the requirements, these are the things we want to know. We just need to incorporate the two, so.
Your rule only gives as part of the requirements to be considered for approval. Speaking to the instructor, it doesn't have any specific requirements. It just is the program it has to be conducted by an instructor, discussion leader, or lecturer qualified in the opinion of the commission by either education or experience or both. That's why she was saying we want to be sure that when we have this form in the final version, we're asking for enough for you all to make that determination of them being qualified. So the instructor approval application, which we were hoping to kind of combine these into one where we could attach separate information where people can just have one form to fill out. At some point, it's our understanding, it was before I got here, that these boxes, these 5 matters underneath, check at least one area in which you meet the requirement for teaching continuing education courses. At some point, it's our understanding the commission said if one of these was met, then that person was qualified in the opinion of the commission. I don't know if that's still you all's opinion. We could incorporate these 5 check boxes if that's something you'd like to know, or if you all would rather just see a resume and biography where you can see a little bit more of a narrative about what they've been doing, where they've been working, what kind of degrees they have, then, we tried to cover it in general terms on the existing new form by requiring them to attach a biography and or resume. So we'll answer any questions you may have.
Personally, I like the resume. I want to know, what their background is, how long they've been doing it. Just because they got a master's degree doesn't,
Right.
I mean,
And
the auction industry is very much a specialty niche business, and you have to understand the nuances of it. And that a lot of times don't come out of a book, and so I'm just speaking for myself, and Howard and Bobby may have different feelings about it. Any comments, Howard?
Well, no, I agree with you 100%. The instructor should be very familiar with the auction. Qualified to conduct an auction if necessary. So,
I'll think of anything other than a biography or resume that we might list here that might,
I would leave what you have on here
okay.
here.
I feel like, we put and or just, and we tried to put,
Or in addition to.
up above here where it says the following items are required, we tried to include, all the requirements so that somebody before they got to that point would see that is the requirement, and hopefully from that glean, I need to give them enough to make
I
this
don't think it
determination.
would hurt to leave these, what you have here, or what we have here on this checklist, but just add, I'm kind of like Jeff and Howard, it certainly wouldn't hurt to see a resume.
Okay, and under the please attach the following, we do have biography and or resume of instructors conducting the education background, including education background information and or experience.
And I think you just cover the last 10 years of their work life. I think that would
Okay.
probably get it done, wouldn't you think, guys? Yeah. If they haven't done it in 10 years, then
Do you want me to put at the end of this over the past 10 years?
that's fine, however whatever,
Okay.
I mean, we don't need their life history, but.
Right.
But I think.
Right.
If they,
Somebody's gonna add everything they can think of on
yeah,
here anyway, even though
they are. That's fine.
Well, more is probably better with the way our
No question.
statute,
No
the way
question.
the rule is worded, because the
Right.
more you all have, the better
Yep.
determination you can make.
But you get some kid you got a PhD in economics, and he's gonna write classes for us. I don't know. I got a problem with that.
Okay.
yeah.
Well, we were trying to condense this from what was in 2 forms into one, and hopefully still ask for maybe a little more information so that there would be less
Right.
follow-up, and,
Okay.
I don't know, I hope
I
this.
applaud your efforts.
On
Well,
this application, is name of sponsor, is that the person that's putting on the seminar or school or
The sponsor
whatever?
would
Could-
be
Nashville Auction.
Nashville
Okay,
Auction
yeah,
School, for
okay.
example, just so
Right.
that we know who the
Okay.
contact information is. In the rules, it refers to the sponsor applying, and then there's usually a separate instructor. That's why there's a line where it asks for a listing of that, and then the additional documentation for any instructors, so. And if you all like this form with the addition of putting in over the past 10 years, that bullet point, if we could just do like we did last month and maybe have a motion to either approve it or
That's fine.
anything
That's
like
fine.
that,
Just-
so that we can get this up to forms review and get it on the website for any applicants.
I think y'all are headed in the right direction there.
I move that we approve the form.
Approve the form with modifications, right? You
Second.
want- It's been moved and seconded. and you make those modifications, you can go ahead and
Right.
put her up.
And just an update on the 80-hour course application. We did get it back from Forms Review, and it will be going up on the website this week.
We have a recovery fee discussion.
Yes, sir. And I actually provided you with a paper copy of this.
This one right here, Howard. We're looking for right here.
And there's also a paper copy of the new form, too, if there's anything anyone else sees.
You want to give us a little background on this?
Yes, we've been reviewing fees and that type of thing with CORE, and we stumbled upon some confusion related to the recovery fee and how the recovery fee is charged and who it is charged to. What you have in front of you is a listing of the application fees, and you'll note the application fee is only charged on initial licenses, and then the renewal is the license fee and the recovery fee. And I'm going to let Julie speak to how the rules and the laws, there's a little confusion about the charging versus,
My understanding is they're a little out of sync.
yes.
The printout that you're looking at that has the title Tennessee Auctioneer Commission licensing fees at the top, that's not something Kimberly prepared from this meeting. That was actually pulled from the website. This is the information that is currently on the website. It's stating that this recovery fee of $50 is being charged for everyone. As you'll see at the bottom, Kimberly put a star next to the public automobile auctioneer and public automobile auction firm, where you'll see her note at the bottom. I think I had one typed.
Yes. It's in your, oh, it's on the
Yes. It says currently these licensees are only paying $225 for the initial and $175 for renewal. So it appears there's a disconnect right now with the information that's on the website telling them what to pay, and apparently what's in the renewal information. So in practice, these two are not currently actually paying the recovery fee. In the statute, 6219-116, which is the Auctioneer Education and Recovery Account statute, it states in subsections C1 and 2, no new auctioneer, apprentice auctioneer, or firm license shall be issued unless the applicant pays, in addition to the license fee, a fee of $50 or a lesser amount that the commission may by rule establish for deposit in the account. And then C2 basically lists the same three: auctioneer, apprentice auctioneer, and firm for renewal. It appears that there's been confusion and everyone has been charged this except public automobile auctioneers and public automobile auction firms. They have not apparently been charged it in practice, although it says on the website they would be. It would be my thought that if they are not specifically named in the statute, that it is probably not something that it's not a classification that should be paying this, because although this statute predated the public automobile auction statute and the gallery statute, it has been amended. It was amended the same year in some other manner, in 1999, the same year that the gallery statute came about. And it would be my thought that if it's not specifically stated to collect it, that it's probably not something that should be collected. At this point, like I said, for public automobile, both of those licenses, it is not in practice being charged. But I didn't know if, I know all of you have a longer history with the commission than I do, or maybe even that Kimberly does directly. I know she's been here a while, but I didn't know if you all knew of a reason why this was being charged of everyone, other than maybe, somebody along the way, even in staff, just thought that it should all be charged. I didn't know if you all knew of maybe why this was the case, or if you could provide any clarification, because there appears to be some confusion within
So it is being charged, but it really not anything in the law that says it's supposed to be, right?
Right. The statute doesn't, and we don't have our rule just itemizes the different fees, and it says recovery account fee $50. It doesn't specify to whom. The only guidance we have is this statute from the legislature. It does not specifically name anything other than apprentices, auctioneers, and firms, which would of course cover firm branches as well, because that's essentially another firm. But it doesn't cover galleries or the two public automobile licensees. And it appears that the public automobile, the auctioneers and auctions have not actually been paying it, although our information on the website says they should be paying it. I tend to think the statute has excluded these by not naming them, but I didn't know if there was some history that you all maybe knew about, or if what your feelings were on this. Like I said, all I can really do is kind of go back and look at the statute and see that it's not really named, but
I don't know that it ever even came up at the time. Do you, Howard?
Well, I think it came up.
Right, you're paying it for your license, you're paying
I
it
see
for
what
your
you're
farm.
saying.
Getting a double whammy at you, that, and actually, I think it should be left like it is, because there's, if you go get an auctioneer license, and then you're paying, yes, ma'am.
So you're saying like they're doing in practice, not like it's stated on the website, not charge it of the public.
I don't think it should have been charged or even stated, because when we got this law passed, there was nothing said about an additional license. If you have an auctioneer license and you pay your fees to go do a car auction, it seems to me like you're just doing another auction.
It predates me, so I have to lean on Bobby and Howard.
I think what Howard's saying is anybody that has that public automobile auction license has already paid it when they got their auctioneer's license, and then paid it when they got their regular farm license, which you have to get a public automobile auction license.
And you're
So-
paying it on renewal as well for
Right,
those.
so
So,
it's-
so then it sounds to me like you all believe that the information on the website should be corrected to reflect what was actually being charged
I'd
right
say
now.
so, I'd say so.
Now, for galleries, we do have the same issue, and I know it's not the same reasoning behind it, but it likewise is not listed in
What
the
about the non-auctioneer galleries?
no type of gallery is listed within the statute as ones that are required to pay it, as licensees that are required to pay it. It's just auctioneer, apprentice auctioneer, and firm license. Those are the only three.
But even the gallery's got to have an auctioneer that pays the fee.
Right.
The auctioneer that would be calling it, would have had to have paid. Like I said, I'm not sure if there was a reason why it wasn't amended. The statute wasn't amended when those other ones were changed, or if it was intended to be left out, as you said. But we can certainly correct the information that's listed on the website to reflect what's actually being charged for the public automobile auction and auctioneer. If we could maybe get that in a motion, and if you all would let me know somehow what you think about the galleries as well. That's another area where
Well,
there's
at the time on the public automobile auction thing, I think the feeling was that it's already being paid a couple times if you got the auctioneer's license and
Farm license.
the farm license. Now the gallery, I don't know. Don't you think that's right, Howard? It felt like it was already being paid. It'd be like double
Yeah,
dipping.
yeah, that's,
triple dipping
that's
in that
exactly
case.
right.
Well, why don't y'all make that in the form of a motion that we change it on the website to reflect what's being done?
Are you including the gallery?
yeah, and I do need to have some I mean, because
I think
you all
you
obviously
need to
make
go
the
back and then look at the law on the gallery, whether they're supposed to pay it or not. I mean, we just want to make sure.
Well, they're
we're-
not listed in the law. I
We're-
mean,
okay.
they are not included in the listing in the statute. I read C1 to you, and C2 is worded identically, except it just refers to renewals
Well, at
instead
this
of
point,
initial.
would it take a law change to change it anyway, wouldn't it?
It would take to add them
Legislative.
to the numerated licensees. That would be the legislature that would
Yeah.
have to do that. That's unfortunately not us.
Right.
But I'm just saying in practice of what we need to know.
I
is-
move that the website be changed to reflect what's actually being done in practice.
Well, but my question is for galleries, there is no disconnect. They are actually being charged the fee, and it states the additional fee. And so my question is if you all want.
About the $50 fee for the gallery is what he's asking.
Okay, we keep on collecting it if we've been collecting it all this time. I don't know.
What'd
Oh,
you-
I'm sorry.
What'd you
No,
say
I
about
mean,
the?
it's not-
I'm sorry. I was
No,
reading the question.
I mean, can we keep on collecting? If we've been collecting, if we've been collecting it unjustly all this time, I don't know, you know.
You know, I mean, I think you can certainly, I mean, you have that option. I think if there was a challenge, I'm just trying to let you know what that argument might be.
Right.
And, you know, I think arguing that a gallery is a firm, I'm not sure how that argument would work considering they have their own separate statute.
The only one that it would really, that's really gonna be getting around paying it in the long run is the non-auctioneer. Don't you have a non-auctioneer gallery?
You do, but even.
But
auctioneer
he's
has-
gotta have a licensed auctioneer
Right,
to auction,
right,
so.
Right, and that's who we fall back on anyway.
Right.
Well, the gallery license have been confusing since day one. I think the reason that we have a gallery license to begin with was to help curb illegal auctions, you know, and I think it's worked out very well. I believe we ought to leave it alone like as it is.
Why don't you make that formal motion?
Gallery and the public. Is that what he made? Am I supposed to second his motion?
No, my motion's gone. My motion failed from lack of second.
Well-
You make a new one.
I make a motion that we leave the gallery license and the public automobile auction license as are.
As charged, not as
As
stated on
charged,
the
yeah.
website.
Right,
So
as charged.
not charge it for the
Public.
public automobile auction
And charge
and
it
correct
for
our
the gallery.
information,
And
but
charge it for the
continue to
gallery.
charge it and leave the information.
Right.
I'm just trying to clarify.
Right,
Okay.
right.
What you said.
All right.
Second?
Second.
It's been moved and seconded. Any further discussion? All in favor say aye.
Aye.
Aye. All right. That's clear as mud, so.
I understand your motion, so we can.
All right. Is there any other new business to come before the commission today? Any old business? All those in favor of adjourning, say aye.
What is this for?
That's just, you can. It's just,
Just to keep.
they hand them to us each time.
I take them back.
Oh, we get to keep these.
Okay.
Each time.
Just keep the iPad.
Nice try.
Well, we can do that after we adjourn.
We are adjourned.
Failure to have a motion.
You come and tell me.
Automatically adjourned.
I don't know.
Well, see if we,
Next
could you
meeting.
get us,
Oh, yeah.
like, could